Welcome to meeting number 66 of the House of Commons Standing Committee on Justice and Human Rights. Pursuant to order adopted by the House on March 8th, 2023, the committee is meeting in public to continue its study of Bill C-295, an act to amend the Criminal Code. Today's meeting is taking place in a hybrid format pursuant to the House Order of June 23rd, 2022. Members are attending in person in the room and are remotely using the Zoom application. I'd like to make a few comments for the benefits of the witnesses and the members. Please wait until I recognize you by name before speaking. For those participating by video conference, please click the microphone icon to activate your mic, and please mute yourself when you're not speaking. Since I believe they're all members and House guests here today, I don't have to go through all the rules of Zoom and whatnot, as you're all experienced from this. And for Ms. LaRoche, I just want to let you know the sound tests have been done, interpretations have been verified. So I'd like to welcome our witnesses for the first hour. From the Department of Employment and Social Development, we have Alicia Ram, Senior Assistant Deputy Minister of Income Security and Social Development. And from the Department of Justice, we have Matthew Taylor, General Counsel and Director, and Isabelle Descharnay, Counsel. And they're not going to be making any remarks, so we're going to go straight into questions, and hopefully we'll get a full round in before we get our next round of witnesses. So we'll begin with 6 minutes with Mr. Caputo.
Thank you very much, Mr. Chair. Thank you to our witnesses. And I appreciate the fact that we have such capable legal expertise in the situation that we need it in, because we do need some guidance. So I had spoken with a number of you earlier, all three of you, just briefly, and I'll get right into this. I'm just going onto my laptop here to look at the text of the bill. So one of the main concerns or questions I have is probably a better put, is that oftentimes when we use terms in law, we'll define them even if they're well known to the public or in the English language. So for instance, everybody kind of knows what a manager is, but when you're looking at putting criminal liability on somebody, that might be something that we define in the criminal code. Did everybody with me so far? Okay, and to be clear, the word manager isn't defined, nor is owner defined. So for instance, an owner of a long-term care facility could be somebody, well, it's likely to be a corporation, right? So the owner is going to be a corporation, not the shareholder of the corporation who may themselves be running it. Everybody with me so far? Okay. So one of the questions I have, and this is the main one, and this will probably take up the 6 minutes, is this. When to commit a crime, a person has to do the act, and in this case, the act would be a failure to provide the necessities. That's the criminal act involving wrongdoing. But there also has to be an element of intent there, right? And sometimes that element of intent might be negligence. That's how it's placed there. The question I have is this. Is there an issue with the constitutionality of imputing or putting liability on an owner or manager who doesn't necessarily have the day-to-day care of the patient who suffers harm? Is that question clear? Okay.
Yeah, I think it is clear, and maybe I can start. I think what I might say to help the committee, and I think it's at the heart of your question, is that the failure to provide necessaries of life, as we would generally understand it, would be things like the frontline worker who provides the care, who provides the food, who administers the medicine, things of that nature, whereas the owner or manager may be one step removed from that day-to-day care. Is that the crux of your question?
Yes, that's essentially it, is that normally if you're going to impose criminal liability or penal sanctions, if you want to put it a different way, there has to be an intent to carry out or the negligence, which is the intent here. I'm trying not to sound like too much of a legal nerd, just so everybody could follow. There has to be that connection between the accused person and the act being carried out. And my concern is whether an owner or a manager, especially when undefined, don't have that necessary connection. And I'd like your comments on
Sure,
that, please.
maybe a couple other comments, and then I'll turn to my colleague maybe to augment. I think I would avoid using the word intent, and I know you're not meaning it deliberate, because we are talking about a negligence-based offense, and so the mens rea for this offense is negligence, and that would require evidence of a marked departure from the standard of care of a reasonable person in those circumstances. So I think that's the first point I might say. I think the bill does try to provide some specificity around the concept of manager, although it doesn't say manager is defined as. It does speak to a person who is responsible for, and then it enumerates a number of different responsibilities. That doesn't speak to your question about owner, and I think you raise an interesting point in respect of wanting the criminal law to be clear and precise, so that those who are governed by it understand what is and what isn't legal, and who the law applies to and doesn't. Chose?
So with your permission, I'll respond to the question in French. The provision in the light of 115.b.1 talks about a manager or an owner that provides the necessaries of life to residents, and to that there can be two interpretations that are distinct. Namely, is an owner or a manager providing the care themselves to the residents, in which case there would be charges of negligence, or are you targeting an owner or a manager who would not directly provide care, but who would be deemed responsible through the action of their employees? So there is another type of involvement that could be possible in this section, and there is the responsibility for the other, which is a concept that is applied in criminal law. But there are two interpretations. There are two possible interpretations under the bill.
Too, for that, Mr. Taylor, when you talk about mens rea, I didn't want to get into the Latin too much, but yes, your point is well taken. We have to establish a mens rea component of a negligence in this case. So, Ms. Descharnais, did I pronounce that correctly?
Desharnais.
Desharnais, sorry. My apologies.
Mr. Caputo, you're out of time now.
Oh,
But you got her name right.
well, Desharnais. No.
Make sure you clip that.
Next, we'll go to Mr. Nakvi for 6 minutes.
Thank you very much, Mr. Chair, and I want to thank the witnesses who are here and their expertise in this manner. Look, I think we've been hearing a lot about this particular bill. It obviously addresses a very important issue surrounding what we saw during the pandemic in terms of loss of life, especially those seniors in many of our communities who are living in long-term facilities. But of course, it's our job as legislators to ensure that that we get the elements, various elements of this legislation right. So I think I will pick up on the kind of question that Mr. Caputo was asking and ask our experts. Is it the difference between the term manager and owner? And I want to know their understanding of what is the difference between a manager and owner is, and how can we, what changes can we make to define it better so that if there's a difference, we can articulate that difference clearly.
So you'll understand that we're not able to give you a legal opinion on what should be amended or changed, but the bill talks about the functions of a manager in which there are different responsibilities that are not cumulative against them. So from the time when there is a demonstration of one of these responsibilities, we get into the definition of manager, and that also with the can it be someone who is a casual employee? So there are two facets to define the term manager, but now concerning owner, given it is not defined you need to seek out the common understanding and the interpretation. So owner would be someone who owns something. It would be the definition for the term owner in question.
Thank you. Am I hearing from you a suggestion that if we choose to amend this bill, that we add the term owner and define that in addition to manager?
I mean, I think it's a good question, and I mean, certainly providing a definition would provide clarity to, picking up on what I said earlier, clarity to Canadians, to the public, as to who these groups of people are. Just to build a bit on my colleague's statement, I think that the concept of owner, a person who is an owner, could also, I think, be captured by some of the duties articulated in the clause pertaining to manager. So it is conceivable, for example, that an owner could be responsible for hiring or scheduling staff. Under this definition, they'd also be captured by manager. So there is some overlap, and I think you've also heard witnesses talk about the opposite concern, which is that personal support workers or the frontline workers who are not generally responsible for the management of a healthcare facility might be captured on a case-by-case basis by the duties that are listed as manager. So it's a bit of a long answer to say, providing that kind of clarity would assist those responsible for administering the justice system to understand precisely how these provisions apply and who they should apply to.
I think I'm okay for now, Chair. Thank you.
Thank you, Mr. Naqvi. We will next go to Mademoiselle LaRoche for 6 minutes.
Merci.
Thank you very much for joining us today to talk about this important bill for a cause that we all care about. But I do have some questions, obviously, and I would like some clarification on a number of subjects. I think we're talking about the definition of owner, which perhaps need to be spelled out a bit, and owner and manager. But there is also the definition in the bill that we can see in Section 214. The definition of long-term care establishments could be problematic as well because they don't mention whether they're under provincial jurisdiction. It's also very prescriptive in that about what a long-term care facility is, and it excludes people who are not necessarily incapacitated, but who are older and choose to live in this environment. So you talked about the definition of the long-term care establishment. What do you think could be problematic in the bill? What you need to understand is that the term long-term care facility is not used all across the country. Some provinces and some territories will call them care homes, long-term homes. So that term is not used necessarily across the country. And then there's a definition that is also a bit is defined by a bit of fragility. So someone who is in for reason X needs daily care could be subject or could need to go to a long-term care facility. I don't know if that answers your question. Okay, so I understand that there may be some changes of interest in that aspect. In 215B, the bill talks about emission or actions that cause damage to the health of the person. It's good to consider health, but how could that fall in Quebec, where there's already legislation for people who are vulnerable? How does that align with what is already in existing legislation, particularly in the case of Quebec? And I'd like to hear from you on that. Well, the provincial legislation, particularly in the case of Quebec, act as a complement. They're complementary. They can work together. The federal legislation seeks to create accountability, a complaints process. It seeks to equip inspectors with powers in order to give more structure to establishments that care for vulnerable individuals, while in criminal law, it seeks to criminalize behaviors with criminal intent. So those two situations can coexist at the same time. They have different objectives, and there can be juxtaposition at certain times, but I think where there is provincial or territorial regulations, and then if there is something with criminal intent, it will be more situated under the criminal code. And there are also a number of kinds of mistreatment. There's physical, there's psychological, financial. There are a number of different types of mistreatment, and we need to be clear about what we're talking about in the legislation. So how does this bill, does it respond to different types of mistreatment? Because there are different situations that arise in a residence. The criminal code contains many general infractions that will talk about mistreatments. Mistreatment is a generalized term, and then there's sexual violence, financial mistreatment, and others fall under mistreatment. So the criminal code sets out general infractions for assault, sexual violence. The reading of the bill is exclusively based on negligence and not other types of mistreatment. So if we want to really broaden this, it's just one aspect of negligence. So would there be possible recommendations to make it broader in scope, or is the issue of negligence sufficient? I can't give you a legal opinion on your question, but what I can say is that negligence is part of a responsibility of one person to another, and omitting to fulfill this responsibility has possible consequences if it could cause damage. So it's true that it is circumscribed in the sense that not all forms of mistreatment, but this bill speaks specifically of negligence. Okay, thank you very much.
We'll next go to the 6-minute rounds to Mr. Garrison.
Thank you very much, Mr. Chair, and thank you to the witnesses for being here today. I want to back up a step from this bill and ask about the existing section of the Criminal Code, Section 215.1, I think it's C, which says it's already an offense to fail to provide necessities for someone under his charge, I think is what it says in that section. So is it in fact already a criminal offense without this private member's bill for long-term care home manager owners to fail to provide that care?
Yeah, I would say it certainly is.
And so I guess that the question then that provides to us is how this bill is going to make that more clear, or whether it's going to expand the coverage. And I would ask again, looking at this bill, does it actually expand the offense beyond what is already in the criminal code?
That's a difficult question to answer because I think ultimately it'll depend how the courts interpret the duties of the managers or the owners. Because I think with the provision you've already mentioned, it speaks very clearly to the person who has a duty to individuals under their charge. So to the extent that this bill goes beyond that, yes, it does, but ultimately it would be for the courts to determine. I think you know as well, oftentimes with the enactment of more particularized provisions, it can be useful to help remind the system to pay particular attention to an issue of particular concern. So it has value in that respect as well.
And is there other legislation, I guess, that would be parallel to this? And I'm thinking of perhaps the responsibility of owners of corporations for deaths or injuries of workers on the job. Is there anything parallel in existing legislation to this?
Alors, vous faites référence.
So I referred to section 117.1, which is from Westray. So Westray talks about the obligations of what happens between an employer and its employees. So this bill sets out rather the employer or the manager toward the residents. So it's not quite the same provisions with the same specifics.
Where that leads me is if we have something which is roughly parallel in the I guess case law around Westray, is there a distinction made between those who have managerial responsibilities in terms of policy and those who have what we'd call maybe line manager operational responsibilities? Has that happened in the Westray cases?
I'm going by a bit by memory, but the Westray provisions did a couple of things. As my colleague spoke to, it created the ability to prosecute corporations for either negligent criminal behavior or criminal conduct that required subjective mens rea. It did impose a duty on employers who have a responsibility over the safety over their workers. So which isn't exactly what this bill does. This bill is about employers vis-a-vis those in their charge effectively. So it's not an exact parallel in that respect.
But we did hear concern from especially nurses who often have what we might call line management responsibilities, that they might be captured under the broad provisions because there isn't a distinction made in the private member's bill as it's presented between, I guess, what I would call senior managerial responsibilities and line responsibilities.
And I think that's an important question, and I think it speaks to the comments of Mr. Nakvi earlier in terms of the way, for example, manager and the responsibilities for manager are laid out in the bill, and how that overlaps with somebody who isn't the senior manager, to use your terms, but maybe acting in a managerial function, and whether that was the intention of this bill was to target the personal support worker, the frontline worker who on a given day assumes the responsibilities articulated. So I think it is an important point for you to consider.
Thank you for that. On the question of the different use of labels for facilities across the country, I think that's something I hadn't really thought about. I think it's an important point. In this private members bill, it gives a definition for a long-term care facility. And I guess I'm asking something you may not be able to answer, but would that cover all of those variously titled facilities in the provinces, or do we have something we need to work on there?
I can give you an overview of how it works in other provinces and territories based on the research that our officials did. There's often mention of a type of resident that has no tie to the owner or manager, and that person is in the residence for health reasons, general health reasons. So what varies across the country is the minimum threshold of the individual. In BC, that is not called a long-term care facility. If you go to Newfoundland and Labrador, there's a 5-person threshold. If you go to New Brunswick, it's 7 people. So throughout the country, the threshold has different disparities.
Thank you.
Thank you, Mr. Garrison. We'll go to our next round for 5 minutes with Mr. Brock.
I get around. So I didn't think I was going to get around. That's a bonus. All right. Thank you. Thank you, Chair, and thank you to the witnesses. I don't believe anyone's asked you a question yet, Mr. Ram. So I don't want you to feel left out. I would like to, I'd like to get your perspective from a ministry official with the portfolio that you are in charge of, what your thoughts are in terms of how this particular private members bill is going to assist in addressing some of the systemic problems that we have in long-term homes.
Thank you, Mr. Chair. So I'll start by saying that I'm not a legal professional, and so I can't really speak to the specific provision of the Act. I do share the advice that's been provided by my colleagues that this is an area where there is some diversity in terms of how some of these facilities are structured, what they're called, how they're organized, and so you should give some thought to whether or not the terminology that's used in this bill fully captures that diversity. Keep that in mind. I would say that there's probably value, as my colleague already spoke to, in terms of increasing awareness of this issue through this private members bill, whether or not it actually captures additional behavior that isn't already covered under other pieces of legislation.
Okay, so if I could just interrupt for a moment. Your Department of Employment and Social Development, are you concerned about the impact that this private members bill will have on not only retention issues, given the broad nature of the definition of manager, which essentially captures everyone from janitor, in my view, up right to the potential typical manager of a long-term facility, and the issue of recruitment. The industry itself is suffering in terms of substantial tens of thousands of vacancies across this country. So they can ill afford, in my view, this industry to have a piece of draconian legislation that is actually going to hurt the industry as opposed to helping it. So your thoughts on that, please.
Thank you, Mr. Chair. I would agree with the member that recruitment and retention is definitely an issue in the healthcare sector at large, but particularly as well for long-term care facilities. Our department is doing some work with the Department of Health, kind of looking at this issue, and there was some funding that was provided as part of the health deal recently announced that tries to address some of these issues. As I said, I'm not a lawyer. And I don't really have a particular view on the scope of the application of this particular private members bill in the sense that you meant it, I think.
How much time do I have left? 2 minutes. Okay, to Mr. Taylor, leaving aside the obvious, I'm sure you've probably heard this from other witnesses before, that the government issued a throne speech in 2020, which specifically addressed elder abuse and specifically telegraphing to the industry and to Canadians and to vulnerable Canadians that this government is actually going to care and do something about the prevalence of elder abuse. You have that issue. You have mandate letters going to the Minister of Justice and the minister responsible for seniors, again addressing a requirement to amend provisions in the criminal code to address these issues, and nothing was done until such time as my colleague Hetty Fry brings a private members bill. So I want to get to, I know that the department does not routinely do charter statements for private members bill, but I'd like to hear from you, sir, because in my view, the floodgates are going to open substantially if this bill passes with minimal or if no amendments, it's going to open up a number of court challenges, particularly from Defense Counsel. So I'd like to know from your perspective, sir, how you feel about the charter application as it currently stands right now, this particular bill.
It's a very good question, and certainly, as you know, when we provide advice to the government as public servants and as lawyers, that advice is protected. But I think you also know that providing charter advice is part and parcel of the work that we do in supporting the minister and supporting the government. You will also know that with any offense or any offense creation, most often they raise Section 7 considerations, life, liberty, security of the person. So certainly that is something that would be looked at and analyzed in providing advice to the government. I think the only other piece of information that I can offer to you would be to point you to our charter PDF page on our Department of Justice homepage, which contains fairly detailed information on Section 7 jurisprudence. And obviously that jurisprudence would inform the development of any advice we would give to the minister of the government.
Thank you.
Thank you.
Next, we'll go for the last one to Ms. Diep.
Thank you very much, Mr. Chair. Mr. Ram, I want to continue in that same kind of line of questioning. You talked about, I guess, the diversity, and we've heard from others about the different terminology that is used across the country when we talk about long-term care. From your experience in what you do, and I know you're not a legal person or an expert in that, and maybe that's a good thing. But given your experience, you would know the staffing structure, I guess, and the number of people that intersect with residents. Can you tell the committee who are we holding accountable? Who should we be holding accountable? And does this bill do something that you think is not already existing? Because we've heard other witnesses that say we've got, and I mean, it was talked here as well, there's criminal code offenses that already deal with some of this. There's provincial legislation in different parts of the country and different provinces that, deal with other parts and so on. What are we missing here? What is the gap from your experience? What is it that we need to be trying to fill here, if there is one? I'm asking kind of, what you've seen on the ground with this kind of stuff.
Thank you, Mr. Chair, for the question. We have done some joint work with the provinces and territories, particularly in the context of what we saw during the pandemic. There was actually a paper that was recently done under the auspices of the Federal Provincial Forum of Ministers Responsible for Seniors that took a look at some of the evidence that came out of that experience. And what we've learned is that there are a number of gaps. Those gaps are often around lack of clear accountability, the vulnerable position that seniors were put in, particularly during the time of lockdown, when it was very difficult for people from the outside to be able to see into those facilities and understand really what was going on. The transition to largely virtual sort of communication, where not all individuals who were living in those facilities had access to the right technology or were comfortable with it. And really there was little ability from people kind of outside of the situation to really be able to perceive what was happening and to speak up or to step in and support those members. So I would say from our perspective, the gaps that we would be looking to deal with, not necessarily within the scope of this particular private members bill, is really to increase that accountability and to create more ways for individuals who are living in those facilities to be able to express what it is that they're experiencing so that they are not left on their own to deal with these situations.
So from your reading of the bill, what's in it there that could help in that?
I'm not sure that which this bill is trying to address.
Okay, how about Department of Justice? We've talked a lot about other laws that exist out there. In fact, actually, I took some notes, but we were talking about in the criminal code, but there could be other, where's the gap? What are we missing? We know what happened during COVID. We know, some of the institutions where our elderly were largely affected. We also know that, some of these institutions, that's where we need to care for a lot of them, because a lot of them were not healthy to begin with. So we take that into account. But there was also more death in those facilities that should have been. I guess that's the summary, if I can kind of put it that way. So what are we missing? What do we need to do? Who do we hold accountable? Can we hold someone accountable? Is there a gap that we need to try and fix? Is this bill doing that?
Alors, ce que le code
What the code contains currently are a series of general offenses that were mentioned earlier that can have, under 215(1)(c), the possibility to charge an organization under that specific section. And that is through when we look at the perpetrators of the offenses, we look at 22.1, which allow us to match the organization's action to what is being reproached. So the code contains three negligence offenses, and then there was a criminal negligence causing harm or death. And that comes back to the objective that was set by the sponsor of the bill.
Yeah, and thank you to the witnesses. I really appreciate your time, and you probably now understand why it was very important to have you here to get some of the nitty-gritties of the bill and how it reflects other parts of the criminal code. Thank you. You guys are now excused, and we'll just suspend for a minute or two to get the next round of witnesses, and we'll begin in a minute or two. welcome back. We have with us via video conference as an individual, Dr. Mary Bilow, professor at University of Sherbrooke and research chair on mistreatment of older adults. Thank you and welcome. We also have Canadian Network for the Prevention of Elder Abuse, Dr. Sandra Hurst, chair of the board. Thank you. And we have CanAge, from CanAge, Laura Watts, president and chief executive officer. And lastly, we have from Elder Abuse Prevention Ontario, Marta Hajic, chief executive officer. So you'll all have 5 minutes to make your opening statements, and then we'll begin a round of questions. So we'll begin with Dr. Mary Bilow.
Merci.
Thank you. I'll be giving my comments in French. Hello, and thank you for inviting me to meet with you as part of your work on Bill C-295, which aims to amend the Canada Criminal Code to add components concerning the neglect of vulnerable adults. I am responding to you as a researcher involved in the fight against elder abuse since 1987, so for 36 years now. Although I retired from the University of Sherbrooke 4 months ago, I am still associated with the university, as well as the research chair on mistreatment of older adults and the research center on aging. In addition, I co-lead a World Health Organization collaborating center on age-friendly communities and anti-abuse. So I come to you wearing many hats, and I have a lot of interest in the issue. It is easy to see the context in which this bill is being introduced. COVID-19, in particular its management and effects in 2 types of living or care environments for seniors, has shed light on structural issues that were already in part known. These 2 settings are, first of all, community living for seniors with or without care and services, and also care facilities for adults and seniors in vulnerable situations. I emphasize this nuance between these 2 settings because it's not clear in the bill, but they both employ managers who are referred to in your proposed amendment to Section 214 as managers. Here are 6 brief points for discussion. First of all, you shed light on the organizational dimensions of abuse. In so doing, you take a step away from the usual definition of abuse, which, implicitly at least, seems to focus on interpersonal interactions with a presumed relationship of trust. I welcome this introduction of the organizational dimension, as it allows abuse to be situated in community and organizational institutional dynamics. Secondly, in your definition of long-term care facilities, you do not seem to include community living, which in Quebec is called private residences for seniors. These are for-profit or not-for-profit rental facilities that offer accommodation only to seniors. To live there, seniors must be autonomous or semi-autonomous. I would like to understand what led you to exclude them. This is all the more surprising given that the Quebec Abuse Act, L 6.3, was amended in the spring of 2022 to include them. And I think we can have a discussion on the subject. Thirdly, you are introducing here not the term vulnerable seniors, but vulnerable adults. I agree with your decision because the various long-term care settings do include people of various ages who are there because of their needs. May I suggest that you use the term adult in a vulnerable situation rather than vulnerable adult? Naming that a person may be in a vulnerable situation shows that vulnerability is not an intrinsic condition of the person, but rather that it may be transitory or related to particular circumstances. This seems more inclusive and less stigmatizing. Fourthly, you are looking at a specific component of abuse, namely neglect. While I understand this choice, I would point out that there are times when the line between neglect and passive abuse is very blurry. Furthermore, you must not forget that there are different types of negligence, like psychological, physical, so there are very different types of mistreatment. Fifthly, various discussions with police officers have made me aware of the difficulty of proving criminal negligence. There are very few trials and convictions for this offense. It requires very specific evidence. I would therefore like to discuss with you your views on the applicability of this potential criminal code provision. What evidence will be required to lead to convictions under this new section? And finally, my sixth point, in section 215.2b, you write, and I quote, causes or is likely to cause permanent harm to that person's health, end quote. I've been wondering about this. I would like to understand the importance you place on the word permanent, because in my opinion, causing harm, whether transient or permanent, must be considered. In closing, I would like to point out that it is wise that you have chosen the Canadian Criminal Code to make these changes, as it is a pan-Canadian code. We all know that in matters of healthcare and health, there are risks of overlapping jurisdictions between the federal government and the provinces and territories. As my legal colleagues say, I respectfully submit my remarks to you and look forward to our discussion. Thank you.
Thank you, merci. Next, we'll go to Dr. Hurst for 5 minutes.
Thank you for inviting the network to speak to you today on this important issue. We commend the committee for its dedication and decision to amend the Criminal Code to acknowledge the abuse and neglect experiences of older adults. The chronic neglect and abuse of older adults living in long-term care facilities in Canada is a long-standing problem. 2 recent reports document the appalling conditions that residents in long-term care facilities experienced during COVID. Legislative support for the recently released Health Standards Organization's new national long-term care standards could help address the problem. However, encounters with elder abuse survivors can occur in hospital settings and in the community. For example, in hospital settings, older adults could be admitted due to existing physical or mental health problems, but also as a result of the abuse, for example, injuries, malnutrition. In 2021, the World Health Organization released its global report on ageism. It brought ageism and elder abuse and neglect to the forefront. Elder abuse and neglect were rampant in our communities and facilities long before COVID. Elder abuse has been a silent pandemic for years. From a 2015 national study, we learned that the prevalence rate of mistreatment was 8.2% among Canadians aged 55 and over. That's over 750,000 Canadians. Mistreatment includes physical, emotional, sexual, and financial abuse, systemic abuse, neglect, and the violation of rights and freedoms. We know that it exists, but we have no idea of the actual size and nature of the problems of abuse and neglect in the community or in facilities. Our knowledge is incomplete because we lack the type of investigations we urgently need, prevalence studies in the community and facilities, substantive theory development, and clinical trials to test our interventions, both socially and legally. CNPEA is one of the many voices calling for elder abuse and neglect to be recognized and addressed at the federal, provincial, territorial, and local level, with an emphasis on prevention and early detection through a collective, sustained effort. Mounting research demonstrates that older adults who experience abuse and neglect are at an elevated risk for a wide range of negative health and well-being outcomes. Yet even as the older adult population grows and rates of elder abuse rise across the globe, it continues to be overlooked and perpetrated by individuals within facilities. Although awareness of elder abuse is likely to have increased, it remains an ill-defined concept within society and for older adults specifically. Elder abuse is a complex issue that requires nuances, responses. There is no one-size-fits-all solution because older Canadians are not a homogeneous group. Layers of identity such as gender, race, sexual orientation, economic standing, and disability have a direct impact on a person's risk of victimization, their ability to report, and to access social services. If we are serious about tackling elder abuse and neglect, we need to start by confronting ageism. By the World Health Organization's definition, ageism rises when age is used to categorize and divide people in ways that lead to harm, disadvantage, and injustice. It can take many forms, including prejudicial attitudes, discriminatory acts, and institutional policies and practices that perpetrate stereotypical beliefs. It's rarely recognized as the violation of human rights that it is. Both the WHO and the UN emphasize the importance of age-friendly communities. That includes long-term care facilities. A supportive, age-inclusive community that promotes health and safety and well-being across the lifespan leaves less room for abuse and neglect to breed. CMPEA has recently completed phase 1 of the project with a group of partners entitled Future Us. It is a clear and articulated pan-Canadian roadmap to increase the prevention of elder abuse and neglect. Thanks to funding from the Department of Justice Victims Fund, we developed a guide with multiple entry points, which will allow us at an individual, organizational, facility level, or government to play a role in preventing elder abuse and neglect. The sector of elder abuse and neglect prevention is a very fragmented one. Not all provinces and territories have a dedicated organization or network, and funding varies across jurisdictions. I feel I have to edit my comments because of your time limit, so I will then jump to our recommendations. And we would thank Graham Webb, who made this presentation to the House in May of 2021, that the federal government include in the Act fund organizations that are national in scope, resort a solid infrastructure, table amendments to the criminal code that would explicitly penalize elder abuse, and in doing so, consider the offense of criminal endangerment, especially with elements covering failure to provide care when a contract for care exists. Identify and implement mechanisms to protect whistleblowers in long-term care in consultation with relevant stakeholders. Provide funding to improve training and enhance resources to facilitate investigations. I would once again thank the chair and the committee for the time in this presentation. I would add a personal note that I have worked in long-term care as a registered nurse for over 40 years. So I do have some biases here. So again, thank you to the committee.
Thank you, Ms. Hurst. Now we'll go to Ms. Watts for 5 minutes. And just for those who haven't seen, I will raise a 30-second card just before and then another time. So just try to keep that in mind. Thank you.
Hello, my name is Laura Tamblin Watts, Chief Executive Officer of CanAge, Canada's National Seniors Advocacy Organization. We are a nonpartisan, not-for-profit organization which works to advance the rights and well-being of all older Canadians. We thanks for the opportunity to make submissions to you today on this bill. We know that the context of COVID-19, the long-standing pre-COVID-19 challenges in long-term care, and seniors' health staffing crisis weighs heavy in everyone's mind for this discussion. By background, I'm a lawyer. I spent more than 20 years working in the field of elder law and elder abuse. I'm past chair of the National Elder Law section of the Canadian Bar Association. I was an advisory and technical member of the National Standards for Long-Term Care Advisory Committees. I'm a faculty member at the University of Toronto's Faculty of Social Work, where I teach law and aging. And I am, as head of CanAge, I supported the previous Just Committee inquiry in 2021, being in favor of creating a very carefully worded criminal elder abuse charge. So given that background, it may be quite surprising to hear that I am here to respectfully submit that this bill should not go further. In common parlance, this bill has been heralded by some as very good-hearted, but wrong-headed. We thank the sponsor for her passion and commitment to seniors and appreciate the emphasis on the issue of institutional abuse. The idea is important, but in our respectful view, the issue does not achieve its stated goal through this legislation. It also seems, based on the background explanation for this bill, to try to use the criminal code as punishment for what we at CanAge believe is a failure of the Canadian funding system or attention on seniors' care generally. Seniors need a system that works, not a system which is underfunded and ignored. We need a robust long-term care system and not punish individuals for working in a system which is actually set up to fail. But very specifically to this bill, our concerns are threefold. First, like so many other witnesses have said, we believe that this bill is overbroad in its wording. It will have significant unintended negative consequences. The language of long-term care itself does not adequately capture the provincial terminologies, which range from residential care in BC to provincial discussions like personal care homes, for instance, in Manitoba. So the language is imprecise. Second, there are already both existing tools and methods combined with ones we hope, indeed we expect, to come down from our federal and provincial governments, such as the Seniors Safe Act and perhaps the new promised criminal code provisions that we discussed so deeply in 2021. We also have the adoption of national standards, which have only been introduced in the last few months. And while there is a $14 billion price tag, about 67% of long-term care homes have already committed or are in the process of actually adopting those national standards. So very specifically for the overbroad wording, the proposed amendments we believe are drafted in a loose way. And we have heard from others that the language around manager and the lack of definition on owner expose existing and future professionals to increased liability, and they would certainly discourage participation in the long-term care sector. Nobody enters long-term care profession with the goal of hurting seniors, and the staff are already so traumatized for what they had to go through COVID-19 that the idea that they're going to have additional criminal requirements targeted specifically at them would, in our respectful view, be catastrophic to recruitment and retention in this area. Specifically, we also take note of the nurses in their recommendations for a deeper consideration about the impact this would have on them. We note with some great concern that this could have even captured our federal minister of seniors, who went back into long-term care at a very, very challenged home in her jurisdiction to help out during a pandemic. Under some of the wordings of manager, she might have been captured inadvertently. We also would like to think about the word vulnerable, and I note with great pleasure my colleague Marie Beaulieu in her discussion that vulnerability is not an intrinsic issue, and indeed to call an older person vulnerable as an intrinsic issue, we believe is ageist. We do underscore the importance of understanding social vulnerability. Our second point is that the qualifications for criminal misconduct are overbroad and vague as well. These amendments, in our respectful view, do not provide greater clarity. They perhaps trod on existing criminal code and indeed provincial legislative provisions. The problem is not that the authority does not exist. The problem is that nobody uses the existing authority. Additionally, as a very well thought out and promised charge of criminal elder abuse that we discussed in 2021, and we urge the committee to consider that robust set of conclusions instead. Last, we believe that Canada is unique in the OECD in not having a national senior strategy. We don't have a national long-term care strategy. We do not have a national elder abuse strategy. Funding to combat elder abuse has not been substantially done.
Yes, Ms. LaRoche?
Appel au règlement, Monsieur le Président.
Point of order, Mr. Chair. I have no more interpretation.
Okay, can we check interpretation real quick? And we'll just give you a few more seconds to wrap up after you just do it.
The channels were switched. We apologize.
Oh, the channel was switched. Okay. So if you can just repeat the last part, and you are out of time, so just wrap it in the last part. So thank you.
Pardon.
Thank you. In conclusion, we believe that Canada is unique in not having a national senior strategy to comparable countries. We do not have a national long-term care strategy or a national elder abuse strategy.
I think we're having the same, sorry, I'm going to suspend, sorry, to stop you for a second. If you can double check on interpretation again, I think the channel was still an issue.
Thank
So,
you. I only have 1 second left, so I'm just wrapping up. Thank you. In conclusion, we believe that criminalizing the staff of long-term care, who are overwhelmingly women, many of whom are newcomers to Canada and racialized people, is not the answer, but the answer is to fix long-term care itself. Thank you.
Thank you, and apologize for the technical difficulties. Last, we'll go to Ms. Hadjic, if I'm pronouncing that right, for 5 minutes.
Hayek. Thank you very much, Mr. Chair, committee members, and fellow panelists. Thank you for today's opportunity to address the proposed amendments to the Criminal Code through Bill C-295. My name is Marta Hayek, and I serve as the CEO of Elder Abuse Prevention Ontario. Our provincial organization is dedicated to the prevention of elder abuse. We raise public awareness through educational forums in communities, and we deliver training across all sectors. We want to recognize and prevent instances of abuse and neglect. While we are not legal experts, our 3 decades of experience have made us experts on systemic challenges, those that hinder appropriate and coordinated responses to the silent pandemic. We work to fill gaps where too many older adults fall, undetected and without support. Taking action to allow for the prosecution of those with governance and executive authority over practices that lead to predatory or abusive behavior towards vulnerable persons is good. Being held accountable would encourage owners and executives to better consider the consequences of their investment, and operational choices for their clients and society would be welcomed. But the proposed amendments in C-295 alone will not address those factors that lead to abuse. Profit over care, which fosters chronic understaffing and age discrimination. Excuse me. Our primary concern remains. We urgently need a national elder abuse prevention strategy, a whole of government approach with emphasis on prevention when crafting policy and legislation, as well as early detection through collective and sustained efforts. Elder abuse prevention in Canada is fragmented, and those affected do not have equitable access to the necessary supports. Elder abuse is not a homogeneous issue. Instead, it is a complex one, and we should all be deeply, deeply concerned about its exponential growth. While the intent to amend the criminal code is laudable and may succeed in punishing some who willfully commit neglectful acts in long-term care settings, it will not significantly reduce instances of abuse. Wider structural reforms to the administration of justice across all jurisdictions are necessary to ensure consistent reporting and convictions. Focusing exclusively on long-term care and using age-neutral language such as vulnerable without additional qualifiers is akin to putting even more blinders on our system of prevention and intervention. Because while 7% of older people reside in long-term care settings, 93% live at home or in the community. And while the devastating Canadian Armed Forces report identified pervasive natures of neglect and abuse in long-term care settings, instances of reported cases of elder abuse in the community rose 250%. Many more cannot or did not report for abuse of humiliation, reprisal, consequences to the abuser, or confusion on where to even turn for help. Elder abuse is a violation of human rights, and it carries with it significant negative impacts on our public health and safety systems. Applying an ageism lens to policy considerations for the protection of vulnerable older persons prevents myopic approaches that leave many in our collective blind spots. Most recently, Elder Abuse Prevention Ontario, as a member of the Canadian Coalition Against Ageism, joined a delegation of Canadians from civil society and government to participate in the 13th Open-Ended Working Group on Aging at the United Nations. Together, our diverse voices called for a declaration of the UN Convention on the Rights of Older Persons. This binding instrument would promote and preserve the dignity, safety, and security of all older persons. Canada and the world must do better, because if not now, then when? At the same time, some Canadian jurisdictions are waiving liability for service providers who fail to provide those necessities of life or provided substandard care during the pandemic. The government, under the Charter of Rights and Freedoms, has an obligation to uphold the rights of older Canadians. This waiving is a step away from that accountability. Inconsistencies and the lack of comprehensive national strategy creates confusion and does little to prevent neglectful practices from continuing behind closed doors. We cannot any longer allow this to remain unchecked. So let's be clear. Let's name the issue and define it to inform better data collection practices and support real and targeted and systemic actions. Let's work together to make sure provincial and federal laws are aligned and that our law enforcement, crown councils, and the judiciary are better able to recognize and have those instruments to respond to elder abuse and neglect. Let's work across all jurisdictions to enforce standards to ensure all Canadians have access to places where they can age safely and with dignity. And finally, let's continue to work together to educate our communities and those who enforce our laws and administer justice, and to provide those supports that people need to self-advocate or to advocate on behalf of someone else who is unable to do so for themselves. This is our submission, and thank you for the opportunity to speak today.
Thank you. Thank you to all the witnesses. I'll now begin my first round of questions. We're just going to shrink the time to 5-minute first rounds and 4-minute second, if that's okay. We'll begin by Mr. Brock for 5 minutes.
Thank you, Chair, and good afternoon, ladies. It was a pleasure to hear your summaries. I wanted to thank you so much, not only for your attendance, but your leadership and advocacy in this area. We are all going to be part of this aging demographic at some point in time, and we need to get this right. It's unfortunate, however, for many of you who are here, that this is almost feels like deja vu. 2 years ago, we were talking about this issue, and this government has done nothing to advance this by way of passing its own legislation. Notwithstanding a throne speech 3 years ago, notwithstanding mandate letters to the Minister of Justice, the minister responsible for seniors, that they were instructed to bring legislation specifically to address elder abuse across this country, they have done nothing. And it's taken a member of the Liberal caucus to bring a private member's bill. And I asked the particular member last week, I asked her about why the government has not taken steps. Why did she do it? Her response was, well, someone had to do it. And I don't think that is the appropriate approach to take, given the seriousness of this issue, the seriousness of not only our elders, but also to the industry at large. So I do want to read a couple of passages from a submission that we received to this committee prior to today's date from the Canadian Association for Long-Term Care. I'm going to read out various passages, and I would love to hear from all of you or some of you as to what your thoughts are with respect to those submissions. Do you agree? Do you not? And ultimately, how you can recommend to us in this committee how we can strengthen this particular bill. There are so many flaws that you've identified in this bill. We really need to collectively work to improve this if we're going to make a difference in the lives of seniors. So I start by saying this. The Canadian Association for Long-Term Care is unequivocal in its support for ensuring anyone responsible for elder abuse is accountable, regardless of where and how it occurs. However, this bill only focuses on a singular setting. It only considers physical abuse, of which protections already exist. The legislation does not consider emotional, psychological, and financial elements of elder abuse. It is our position the best way to address gaps is for the government to develop and consult on well-considered legislation that addresses elder abuse in all its forms and all its settings. We urge the government to recommend against passing Bill C-295 and instead call on the government to introduce comprehensive elder abuse legislation in its place. Secondly, the CALTC is deeply concerned that the approach is flawed and not well considered. That's in relation to the problems with retention of employees. As outlined, the human resource challenges in long-term care homes are already at emergency levels. By targeting the people who work on the front lines providing critical care to vulnerable residents, we expect the legislation to exacerbate those challenges. And then lastly, they put together a recommendation to replace the word long-term care facilities with licensed health care facilities, thereby ensuring no matter where care is provided, it is held to the same standard. Also to replace the definition of owners and managers with health care professionals, ensuring all staff, regardless of their role in providing care, are held to the same standard under the law. To anyone, please.
Thank you for the opportunity. I would offer that CanAge is in strong support of the first two, but actually my understanding of Caltech's submission is that they're not really in favor of amending the legislation, rather that this legislation they believe is sort of by its nature not constructed to achieve the aims. And we would offer the same thing. We agree with the first two pieces. I don't think this legislation that's drafted achieves its goals, but certainly we are long awaiting promised legislation from this federal government. We are long awaiting the promises out of 2021 when we all presented, each of us here at the same Just Committee. So it is an opportunity, I think, to reinvigorate that conversation. I worry that tightening up the words will not necessarily achieve our goals, and that perhaps different forms of moving in our legislation is the better approach.
Can I raise another point then?
Very quickly, please.
To address your last statement, it is not just registered nurses and nursing staff. There's a diversity of staff who work in facilities, and we have to acknowledge that. Housekeeper, dietitian, visitor, they all have to be addressed to prevent abuse.
Thank you. Next, I know, Ms. Boileau, you have your hand up, but you'll have to answer it in a subsequent question unless you're having sound issues or otherwise. I will next go to Ms. Briard for 5 minutes.
Merci, Monsieur le Président. Thank you, Mr. Chair. And I will address my questions to Madame Beaulieu. Thank you for joining us this afternoon. I had the privilege to hear you during this committee's study on mistreatment, which resulted in the report on mistreatment of the elderly, fighting against all types of abuse in June 2021. Which you participated at, as I just said. During your testimony, you mentioned a number of points. One of the first was that there were two environments, and that introduced the organizational dimension, which allow us to situate mistreatment in a broader context. And I would like to give you the opportunity to give us a bit more details about that. Thank you, Madame Brière. Yes. When I look at the bill, it's very clear that we're just an organization. So I just reiterated what was said to me before, that most seniors, elderly, are not in institutions, and this works only on environments in which seniors live in a collective setting. And what struck me is that there are a lot of alternatives to traditional homes for seniors, and here there's just one kind, and that seems to be long-term care facilities, which are the most intensive care for people who have a large loss of autonomy. Was that really recent work that I've done in collective living for seniors showed me that there was mistreatment by employees against residents, but also among residents themselves. All too often, we associate mistreatment against the elderly with interpersonal, but now we have a broader understanding of it, and we understand that it can be communities against seniors, and that means that it is a bit more systemic. I heard my colleague when she was talking about reflecting on the management of funding, and I completely agree with her. But I have looked at the bill by saying, what's being asked in the bill? And what I see is that greater responsibility of owners and people in management positions. I think that greater responsibility for these people is a good thing. I think it was an administrative, organizational component on which they wanted to sort of tighten the screws, because one of the things that the pandemic taught us is that we tried to point fingers at who was responsible and we couldn't figure it out. Thank you very much. The second point that you raised was that the bill talks about vulnerable adults, and you proposed adults in a vulnerable situation, because I liked that you said it showed that it's not intrinsic to the person, it doesn't define them. And I'd like to hear you talk about that a bit more. Yes, of course. So there is more work on vulnerability now, and we have noted that vulnerability is not just reduced to a health problem. Doesn't boil down to an inability. It is a concept that is much broader and based on circumstances, and people can be placed in a vulnerable situation or at a certain given time in their life, but that doesn't mean that they're vulnerable. So talking about vulnerable adults can be very ageist, it can be very reductive, while looking at all of their situations to see what are the characteristics of the person, but also the characteristics of the environment in which they find themselves. Because the things that we've learned in our studies on mistreatment over the years is that the context and the characteristics of the people or the organizations of mistreatment tell us a lot more than the characteristics of the senior. So I think we need to look at those different analyses. I have 30 seconds left, so I'll just use that time to thank you for your know-how, and thank you for all the work that you have done to improve the cause of the elderly and reduce mistreatment. Thank you very much. Thank you.
For 5 minutes.
Merci beaucoup.
Thank you very much, Mr. Chair. I thank the witnesses for joining us today to talk to us about this bill, which deals with a very sensitive issue of mistreatment against the elderly. But I will start my questions with Ms. Beaulieu. I had the opportunity to meet you in my former life at the University of Sherbrooke when I was working as a project head on a project that dealt with mistreatment against elderly people, and I was able to have discussions with you, and I thank you for what you brought me in my work, and I also congratulate you for your expertise and your commitment. I'll start with the first question. You addressed in your second point the fact that the bill, if I correctly understood what you said, that this bill sets aside the issue of RPAs, given the importance of this. There is a more diverse places where seniors are sometimes housed at that stage in their life. Yes, certainly. Aside from the traditional homes, there is now a wide assortment of places where seniors can live. So those communities are just as important as a care facility, because in collective facilities there are services. When seniors find themselves in private residences, whether they are for-profit or not-for-profit, they can find themselves in these circumstances. They can have intermediary resources or family resources. So if we have a bill that is limiting itself to long-term care facilities or seniors' homes, I think that we're missing a certain number of situations that are created by the idea of collective care and services. Thank you, Madame Beaulieu. Secondly, I think it's on your point number 5. You talked about working on the programs in Quebec with police officers, and I agree with you that the notion of applicability is very difficult on these issues. And you even said, if I'm not mistaken in your remarks, I'd like to hear you more on the fact that currently there is a difficulty to apply the law, and you talked about the work and of testimony of police officers. Well, yes, I worked closely with a number of police services, and what was striking is that you could see a certain number of files that could deal with the criminal code, but it was very rarely criminal negligence, which led me to ask colleagues my questions of my colleagues to ask. And they said that the case is very difficult to prepare, and it meant that few of complaints were formally lodged and made it before the courts, and that if they did make it to the courts, it was very difficult to secure a conviction. So it was an observation where police officers seemed to feel powerless, or they felt that there were a lot of challenges on the matter. And that's what I fear, is that if there's a new nuance of negligence, then we would also need to provide the means to have objective criteria to demonstrate that they achieve a certain amount of success. Otherwise, it will be used very infrequently in the criminal code. And concerning the fact that this bill does not really deal with the issue of ageism, as many witnesses have said, what would you say to that? Well, I didn't see anything on ageism here. What we see is a concern for people who may find themselves among those who have the most needs and the need to protect them. But once again, we need to be careful. It's not for all seniors. Not all seniors are in a vulnerable situation. Not all of them are incapacitated. You need to respect and strengthen self-determination and protect at the same time. Quickly, in 10 seconds, I would just like to say, Madame Tamblin-Watts, quickly, the issue of funding in health transfers, how could that provide more assistance in the future for seniors?
It is seniors care bucket of funds, which is then negotiated with the provinces and territories, not just for health, but for all issues related to our aging demographic, including elder abuse.
Thank you. Now last with Mr. Garrison. 5 minutes.
Thank you very much, Mr. Chair, and I want to thank all the witnesses today who I think have done a good job of reminding us of the larger context within which this private members bill sits. What I can say, of course, as a New Democrat, is that we are concerned and have made part of our confidence supply agreement with the government a commitment for a safe long-term care act to be introduced to take care of the fact that long-term care is not covered in the Canada Health Act, and that would allow us to address some of the broader issues of the way the system operates, the funding and the standards. So we are aware of the Liberal promises, and we are aware of the agreement we have with them, so we look forward to that coming forward. So what we have is this private members bill, which I think is clearly responding to the large number of COVID infections and COVID deaths during the pandemic. And I guess what I'm wondering here is whether there is something useful that this bill can still do, even if it doesn't address those broader issues that this committee addressed in its study on elder abuse or of the larger needs of the long-term care system. So one of the things we heard testimony on, and I'm going to ask Ms. Hayek, I think she made reference to this, is the conclusions of the studies of the crisis during COVID that caused the Canadian military to have to enter long-term care homes, found a significant difference in the performance of public and not-for-profit long-term care homes and the for-profit homes when it came to the number of COVID infections and the number of COVID deaths, both among residents and the staff. And I wonder, Ms. Hayek, if you could comment on those conclusions.
Well, thank you, Mr. Garrison. I think it brings us back to the point of accountability. So whether it's a for-profit or non-for-profit, the rules have to apply the same. The persons residing in these homes are suffering from neglect, abuse. The staff are definitely overworked or understaffed. The challenges were tremendous. And I think as the global community, we were responding to just the novelty of what this pandemic meant. People living in congregate settings certainly paid a higher price.
I think I, watching the screen, saw you react to this. Would you like to respond on the same topic?
Right. Yes, thank you very much. I think it's important to remember that we didn't include it with the Canada Health Act, mostly because in 1987, we didn't live as long as we did and our frailty wasn't as frail. I think it would have been a very good thing to include it. And I think now it's going to be very difficult. And so we have been very interested in pushing forward with the Liberal promise for a Seniors Safe Act to create legislation that will be thinking about these issues in a substantive and funded, frankly, way. And while we are very concerned about the equitable care of people, I think it's very important as well to fund our new national standards. Many of us participated in that. I think everyone on this call participated in it. We gave, hundreds and hundreds of hours to create new national standards, and we need to have those funded. And those people need to be held to account, whether they be municipal homes, not-for-profit homes, or for-profit homes.
And thank you. And given that time is about to run out, maybe I'll just go around the table and invite Dr. Bolio and then Dr. Hurst to make really some concluding comments at this point.
Marie Singer first. I think amendments need to be addressed recognizing that older adults need to have quality of life and need to have value of their human rights. You're looking at, in the Act, the consequences. You're not dealing with the cause of the problem, in my view. So thank you for the opportunity to comment. Marie?
Yeah, merci.
Thank you. The bill here is really to react to very specific situations, and it's looking at a very specific situation, but this is far from an overall portrait of the situation. So if this amendment was adopted, it certainly wouldn't fix the problem of mistreatment of the elderly in Canada.
Thanks once again to all the witnesses, and thank you, Mr. Chair.
Thank you, Mr. Garrison. That now concludes our meeting. I want to thank all the witnesses for attending. I really appreciate your time and your in-depth knowledge in this from an academic or from actual real-life experience. So appreciate that. I believe Mr. Brock had something he just wanted to ask.
Thank you for the opportunity, Chair. The Vice Chair of this committee brought to my attention that Maine estimates are due at the end of this month. And if we want to speak to it, which we do, we have an opportunity on the 29th, and we'd like that to be scheduled.
Anyone else have any comments on that? I will check as to my calendar. Mr. Nansingari?
Thank you, Mr. Chair, and thank you, Mr. Chair, and thank you, Mr. Brock. I can check the availability of the minister and get back with respect to his availability for the 29th. If not, then we can look at another date.
Sounds good. Thank you, Mr. Brock. Appreciate it, Mr. Nansingari. And the meeting is now adjourned. Good job.